welcome to Mistakes Lawyers Make. We have a great panel this morning, and I'm pleased to introduce Justice Chavez, Bill Sleece, Briggs Cheney, and Don Jones. The materials available for this session are available in your app or on the flash drive that we provided when you arrived. Just let us know if anyone would like an emailed copy after the program. And I'll turn it over to you. Thank you.
Thank you very much, Heather. I went to University of New Mexico Law School many years ago and have been in the private practice of law in Albuquerque since then. Albert Einstein once said, "The difference between genius and stupidity is that genius has no limits." And in the practice of the law, we find that out frequently, that there are no limits to the kinds of mistakes that people can make, both in the practice of law and our clients. Ron Taylor picked up on this idea and thought it would be a good idea to talk to third-year law students about some of the mistakes that attorneys in practice have made in their careers, and perhaps to help them as they begin their law practices in the profession to avoid making some of these mistakes. We've presented this panel discussion to third-year law students for the past 2 or 3 years and thought it might be something that would be of benefit to other members of the bar to not only share the experiences we have had, but perhaps if we have time to share some experiences you have had, not necessarily mistakes you've made, but perhaps that other lawyers or judges have made in the profession, so that we can all benefit and learn from those mistakes. I'd like to turn the program over at this time to Briggs Cheney, who's going to be talking about, among other things, retainer and letter agreements, and defining the scope of representation at the beginning of a matter with a new client. Briggs?
I think I'm going to stay up here if that's okay with you all. When Don asked me to help out this morning, I sat down and I decided, he told me this was the senior lawyers was putting this on, and so I did a little memo to him. I wasn't sure if I had to do something material-wise, but I don't know what was going through my mind, but I decided that I was going to come up with my hit parade of mistakes that lawyers make. And I guess I was trying to be cute in my own mind, thinking senior lawyers. I look out here, there are some senior lawyers, but I think probably a lot of folks who aren't senior lawyers and don't remember the hit parade. But that was something back in the day, as they say, of songs that were on the hit parade. And so that's how I kind of approached this. Some of you know me that are in the audience. For reasons that may, that I can't explain, they certainly weren't by design. But when I started practicing law, I ended up, it totally was, I won't say by mistake, it just happened this way. I ended up representing lawyers. And back in the early 70s when I started practicing law, legal malpractice was not what we know it to be today. And I'm not sure what the reason for that is. I like to think the reason is that, and I do look at legal malpractice as being something that is good for the profession. It's lawyers, our profession, saying we can make mistakes, and when we make mistakes, we ought to be accountable. The thing that is probably also good about it, I mean, it's never fun to be the recipient of a legal malpractice claim, but we learn from those claims. And I will tell you that I started, I guess, in 1972. Over that period of time, the practice of law has improved immensely because of our profession. I mean, we have disciplinary counsel and whatnot, but our profession through bringing these claims has, I think, taught us all how to be better lawyers. So We talk about mistakes this morning. I guess they're mistakes. I think all these mistakes are something we can learn from. The first thing I would like to talk about today, and this truly would be on my hit parade of, and I won't call it a mistake, but things that a lawyer can do that might avoid a mistake. And again, I just have had this opportunity in my career to represent lots of lawyers. I will tell you that this would have changed the day in probably 70% of the cases I've had to handle, and that is having some type of written understanding, a retainer agreement, a fee agreement, whatever it is. Now, back in the day, we didn't have to have those. As we all probably know or you all know in the audience, basically, until recently, the contingency fee agreement was about the only thing that really had to be in writing. But I see John Bannerman in the audience, and there's a bunch of us that have long been on the members of the Professional Liability Committee, now called the Professional Liability and Insurance Committee. And we have done seminars over the years, and without fail, we would lecture to everyone, for gosh sakes, please do a written fee agreement. Well, those days are over. And I'm being a little general here, a little maybe not careless, but with the recent changes to the rules of professional conduct, just about everything you do as a lawyer, even if it's going to go to the bathroom, you better have it in writing. And that's just the way it is. You cannot have I mean, there are some exceptions, but very narrow, but just about anything you do, if you're going to represent a client, that understanding and that agreement has to be in writing. If you don't have it, you have a problem. You are violating the rules of professional conduct. The rule is 16-105, subparagraphs B, C, and D. That's the rule. Here's the reality of it. And I guess because now we have to, and today because now we have email, I use email probably as like everybody else. I'm not a great, I shouldn't say I'm not a great fan of it. It is a wonderful tool. It also has it's a double-edged sword of some sort for all of us. But it does provide the opportunity, it does make the ability to reduce to writing, to comply with the rules of professional conduct so much easier. And an email probably is, not probably, it is okay to serve as a retainer agreement, a written understanding. It's not perfect. What I try to do, if I have the opportunity, is I will try and do the old-fashioned retainer letter, just like we all would hope we would do, and I will then generally send it with an email as an attachment. But however you do it, and letters have, as all of us have lectured over the years or encouraged over the years, a letter takes a fair amount of effort. I was private in the Army for 6 years, and I was a clerk typist, so I've learned how to type pretty well. I will type my own letters, but some lawyers are a little more old-fashioned, and they may have some other method by which they create their letters, and that takes time. Maybe you dictate it, whatever, somebody types it, you look at it, you proof it, and then it gets final, and that takes time. The email today makes it a lot easier. But here's what I'm suggesting to all of you. If you will simply sit down when you've met with a client, you've agreed to represent that client, if you'll do nothing more than to sit and you get that client's email, you sit down at your computer, and it doesn't have to be formal. It doesn't have to have at the top retainer letter or engagement letter. It simply has to be a written understanding. And frankly, sometimes the written understanding, something that is less than lawyer-looking, is almost better. But you can write a letter to a client or an email to a client, and you can say, enjoyed meeting with you today. I'm agreeing to help you in this legal matter. I understand what you would like me to do, and here's what I understand. And then if I can get you to, and it is so easy today in the world of email, to simply sit down and really say it in real words about what you're going to do. Not say, I'm going to represent your interests. You want to lay out in as much detail as you can. If you can put a fence or a border or whatever around what it is exactly you're going to do, you will save, you do a number of things. One, you're complying with your obligation to communicate with the client. Number two, you're saying to the client, here's what you've asked me to do, or at least this is what I think you want me to do, and you're putting a limit on what that is. Where lawyers in the olden days would get in trouble is when they had no agreement, and so there was no way of saying what you were going to do as a lawyer for a client, or you'd have the form retainer agreement that said, you're retaining me, I'm going to represent you in this matter, or I agree to represent you at an hourly rate of X dollars. And what is that? And I've had so many cases where a lawyer was engaged to do a specific task, and the lawyer may have done that specific task. But then what happens is, and it often happens in transactional areas or real estate areas, where a lawyer's engaged to perhaps do an LLC or form a corporation or whatnot, but then 2 years later, something happens with the corporation, and the corporation ends up having something go awry. They turn around and sue you, and they blame you because you're general counsel for that corporation. And you say, well, hold it, I was not general corporation. I was retained just simply to form the corporation or do this or do that, or the same can be true in real estate. And it just happens. And then it is your word against their word in a courtroom. But if you have, from the very beginning, said, here's what you've asked me to do, and then you lay out in your email or your letter, here are the terms of our understanding. You're going to pay me so much an hour, or this is the retainer, or I'm asking for a retainer which will be put in trust and from which I will bill against. And when that retainer is depleted, then I'm expecting that you'll replenish that retainer. I'm going to charge gross receipts. You'll be responsible for costs. And then you may end your email. I'm not sure. I think this works. There's nothing black and white in the law, I don't think. But I believe that if you say in a concluding paragraph of a letter or an email, I'm assuming this is acceptable to you. If not, if you disagree, if I've misunderstood, please advise me. Otherwise, I will accept that this is our understanding of going forward. If you do that, I promise you, you may avoid the legal malpractice claim. Regardless, you will have complied with the new rules. And thirdly, you've done the most important thing, and that is, I had a client once that we settled a case, and I said, well, you should learn. I guess you've learned how to write your cover your ass letter. And God bless him, I can't think who he is, but he responded to me and he said, you know, that's not the way you should look at this, Briggs. And I said, well, I'm sorry. And he said, you know, the important thing here is to communicate with a client, and that is, clients hear the good things, they don't hear the bad things, and so if we can communicate in as many different ways, and the retainer letter is one way, and Don's looking at me saying, you've talked too long. So, thank you.
Thank you, Briggs. Bill, you want to talk with us about keeping track of time and services?
Sure. So for a moment, this is a discipline-free zone because I can't see most of you anyway. So I want you to be honest when I ask you some of these questions, and as you know, I prefer when you sort of participate as we go rather than wait until the end. And I'll sit still as long as I can. I normally tend to wander. We get about 700 complaints a year in the disciplinary board office, and they're in a variety of things, of primarily from clients, what they think their lawyer did wrong. Almost all of those complaints finish with, what do you think? What do you think they often finish with? My lawyer did X, Y, Z wrong, and Mr. Bannerman's correctly right. And by the way, he charged me way too damn much for what he did wrong, right? And so there's a fee component to almost, I'd say, a very high percentage of the complaints we get. Now, how many of you actually charge for your work? right? Some of you like to get paid for what you do, so you do charge. And when we get those complaints and look into whatever the heart of the complaint generally is, and sometimes it really is just about the fee, the complaint tends to come in a couple of forms when it really is about the fee. One, not just that it's too much, but I don't know what my lawyer did with it. What happened to my money? And that's another way for a client to say, I'm not getting an accounting from my lawyer. I'm not getting communication from my lawyer. And so there's some issues there under both 16104, which requires you to communicate regularly with your clients so they make informed decisions. And there's a 16115 issue because when you have your client's money and they ask you to account for it in some fashion or how you spent it, they expect then to see a bill of some kind that gives them some reasonable explanation of what you did. Something along the lines of worked on matter is probably not going to be sufficient to give your client information about what you did, and it's probably going to be insufficient for the disciplinary board when we get it, but you'd be surprised at how often that's the response we get when we ask about fees. So keeping track of your time and doing it in a contemporaneous fashion has a couple of benefits. One I learned from Art Beach very early, who I practiced with in the first 4 years of my law practice, that contemporaneous timekeeping is important because, one, if you're not keeping contemporaneous time, you're either cheating the client or you're cheating yourself when you go back and try to remember what you did a week ago. And then, two, from the perspective of a regulatory body, we're interested in seeing what you've done and that you can justify the fees in connection with the work that was performed. I think we've done this work long enough that we have become astute enough, whether you believe it or not, to sort of pick up on trends where we see a lawyer doing what we call pencil whipping a bill. Anybody know what I mean by that? Yeah? John, what does that mean? What do you think that means? Not that I would think you've done it, but... Right, and what it's doing, it's not keeping contemporaneous time. It's waiting until somebody actually asks you to show your accounting, and then it's like, oh my God, I've got to create an accounting, and it's going in and essentially making it up out of whole cloth. You sort of look at your calendar and you know that I spent, well, sometime on this day working on some pleadings and sometime that day on a hearing, and you just make it up. The problem with making it up is it's inaccurate, and it tends to be, surprisingly, I'm teaching you a trick maybe, right? It tends to be in whole round numbers, and that starts making it obvious what the lawyer has done. We can take a look at that, and we're pretty good at knowing. So keeping track of your time more generally gives you a basis when we ask about it to respond to us in a way that makes it clear that you were keeping contemporaneous time, and it protects you when you've got that excessive fee claim in our office. The other issue that we often see, and the other reason that you should be keeping track, is how many of you charge retainers. You ask your client for money in advance. Nothing wrong with that. You can say you do. In fact, it's a good thing from a business standpoint that your client has some investment in their own case. If you take a retainer, where does that have to go? Trust account, right? And anybody, you don't have to raise your hand for this. You can silently hang your head in shame and go home immediately and fix this. If you're charging anything that looks like a non-refundable retainer, or if your contract provides that you earn when paid, for at least 15 years now, under State versus Dawson and In re Dawson and In re Yalcutt, non-refundable fees taken in advance are simply prohibited, right? That's per se a violation of 16105. Money's got to go into a trust account if it's not earned. And it's got to be earned incrementally, whether it's hourly, whether it's some other benchmark case event. That way, if there's an interruption in the representation, you can give back to the client whatever the client is entitled to. It's another reason to keep contemporaneous track of what you're doing so that you and the client can come to some agreement that usually will not result in a disciplinary complaint when they ask for a refund, because you'll be able to calculate fairly accurately, hopefully, what they're entitled to in a refund. I say that, and it's probably obvious to all of you, but I will tell you that probably not a week goes by that when we get a retainer agreement from a lawyer in New Mexico, it has the words, earned when paid non-refundable. That's simply not allowed. Now, I will tell you, I normally ask the lawyer to fix it, because my assumption is the lawyer has not been paying attention to that development. And if they fix it as a rule, that's sufficient to cure the concerns. If they don't fix it as a rule, that's a violation that then requires some disciplinary action.
Thank you very much, Bill. Justice Chavez, you want to talk to us about communications with the court?
Communications with the court. Before I go there, there's actually a theme developing here, and it seems to be communications. And when I talk to incoming law students, I tell them that basically what you're going to learn in law school is how to communicate with a variety of different people. Your client, and we heard from Briggs, that begins from the retainer system. Then you'll be talking to other lawyers, to staff people, to judges, to jurors. And so it's all about having communication skills. I know that being in the disciplinary system, involved in it for, 30 years, that the number one complaint that the disciplinary board gets that does not reach us on the court is failure to communicate with your client. Not returning calls, ignoring those calls, not keeping the clients informed about the progress of their case. That occupies a lot of time in the system. So communication is very important. I could go on for an hour about communications with the courts. Let me reduce it to one word: respect. And I think if you read our rules, and local rules, by the way, it's very important for you as attorneys to remember that each district has their own local rules. I'll also tell you that we are on the Supreme Court are now looking at trying to consolidate the local rules so that there's more uniformity and consistency throughout the state of New Mexico. But understanding that there are local rules and how you communicate in writing with the judge is very important. Above all, though, when I say respect, that doesn't just mean respect for the judge. I think the judges in the audience will agree with me that if you disrespect their staff, you've caused some serious problems for yourself. So always respect the staff. Don't think that you can be demeaning to them, that you can demand of them scheduling issues or anything of that nature. Treat them with equal respect. Now, communicating with the judge, I'll try to. Let's talk first about the written communications. Filing a motion with a judge that has hundreds of pages of exhibits without really identifying where in those exhibits the important information is located is going to waste the judge's time. Our trial judges have over 1,000 cases each a year to deal with. So they really don't have the time to mine the data. That's your responsibility as a lawyer, to mine the data for them. In fact, some districts actually require you to highlight precisely where in the record the judge will find the uncontested fact if it's a summary judgment motion. And those rules are designed to be cause you to be efficient. It's to efficiently resolve the issues, not only for the judge, but it's actually for your opponent. And to think that it's appropriate to go ahead and hide information within a motion and make judges and your opponent work extra hard to be able to decide what the issue is and what the facts are that support the issue is a big mistake. You should always remember that there's a difference between a trial court and an appellate court. We see everything that is filed in the district court, so we know from looking at the record what you're doing to the trial judges below. So we see that. We get hundreds of pages of exhibits too, and maybe a fraction of the exhibits are relevant to the issue that is before us. But instead, what the lawyers tend to do is cause us, because they believe we have clerks with unlimited time, to go through the record themselves and find the information. So my recommendation to you is to always remember to respect the court. If you have a solid case, then you should be able to make that case within the page limits that are filed with the trial courts and with the appellate courts. Trial courts are a lot busier than we are. We have time to digest what you have to write about. But the trial courts have such a heavy caseload that you have to figure out ways to be more efficient with your presentations to the trial courts. The other thing I would tell you is that don't be strident in what you write. It doesn't really work to characterize somebody's argument in a particular way. You should always approach the practice of law with respect and dignity. You might be offended by what your opponent has done, but it's okay to disrespect the deed, but you should never disrespect your opposing counsel or the participants in our system of justice. If there's any branch of government where people ought to be able to show up and believe that they will have their day in court and be able to tell their story without being accused, belittled, and provoked, it's the judicial branch of government.
Thank you, Your Honor. When you're communicating with your clients, there are 4 or 5 areas that I want to just highlight for you. Number 1, try to set realistic expectations. Don't oversell your client's case. You don't have to undersell it, but don't just tell them what they want to hear. Try to be as realistic as you can in assessing the likely outcome, the merits of your client's case, and when you find out information that affects the probability of success, even if it's negative, you need to share that with your client. Secondly, don't overpromise. Sometimes we're guilty of telling our clients that you've got a winner and you're likely to recover millions of dollars, or in the case of transactional work, you tell them it's a simple will, there's not going to be a problem with it. I'll give you a brief example of that later. The American Bar Association several years ago conducted a study about complaints or grievances that clients have had with their attorneys. And the number 1 grievance that resulted from that study was not that their fees were too high or that they lost the case, but they failed to keep the client informed as the matter progressed to a conclusion. And this is incredibly important now, particularly with the rapidity of communications. With emails and texts, you need to respond promptly. And in our office, we try, anytime a client calls, number 1, if we can take the call then, to take it immediately. If they send you an email, to try to respond immediately. But as you know, sometimes that's impossible because you're with another client, or you're preparing for court, or you have to finish a brief by a deadline. But at least try to get back to them that same day. If the communication comes in at the end of the day, try to get back to them the first thing the next day. And clients appreciate that. Secondly, try to confirm the accuracy of any factual information that your client gives you, including documentation that they may give to you, before you represent to the court or opposing counsel that something is factual. Make sure that you've determined in your own mind that it is. And I want to give you a brief anecdote of a case. I do a lot of business law, real estate, wills, trusts, and probate. And I had a woman came in, and a very close friend of hers, who was a man who lived down the street, had a serious illness. And for the several months prior to his death, she was his primary caregiver. His children lived elsewhere. And so one day, close to the end, he knew that this woman was renting her property, and she had concerns about her situation in life. So he changes his will, and he told her, don't worry about where you're going to live. He said, in the event of my death, I'm leaving my house to you, and I've changed my will to do so. And just so you know, I've left everything else equally to my children. Well, the client brought the will in. I looked at it. It was signed, appeared to be signed by the testator. There were 2 witnesses who had signed that they had signed in the presence of the testator. It had a self-proving clause that was acknowledged before a notary public. Looked like a fairly simple estate. So I filed a petition to have the will filed for informal probate. The woman was named as personal representative of the estate, and the court appointed her as personal representative, entered an order admitting the will to informal probate, informally appointed her as personal representative. Then the children filed a action after we sent notice to them that this was pending, and they challenged the validity of the will. So I called the woman back in, and I happened to know her husband, or her oldest son, who was an adult, and I had him come in. And I said, do you guys know the witnesses who signed this will? And the son said, oh, yes, they are his next-door neighbors. And I said, because there's a challenge of the validity of the will, would you go talk with the next-door neighbors to confirm that they were present when the testator signed and that they signed the will in his presence and that he signed the provision before a notary public acknowledging the self-proving clause. He went to him, came back the very next day, and he said he talked with both the neighbors, and after the testator signed the will in his house, and he had drafted the will himself, by the way, he went next door to his neighbor and he said, I signed this will, would you sign as a witness? Then he goes to the other neighbor who was not present at the same time and said the same thing. Would you sign this will as a witness? I've got to have two witnesses, and I signed this will, this is my signature. Then he takes the will with all three signatures, takes it to a notary public at a bank, of all places, I won't mention names, and said, would you notarize the three signatures? I was there and I signed, and I saw these others sign, and they notarized it. Well, I had to go to the judge and say, Your Honor, I've determined that this will is probably not valid because the witnesses did not sign in the presence of the testator and it was not acknowledged in front of the notary public. So in any event, you need to verify the facts before you rely on them and represent those facts to a third party. Briggs, would you talk to us a bit about professional liability insurance and the nature of the coverage under that insurance?
Sure. Also on my hit parade, I guess, would be or is professional liability insurance. Probably what we're experiencing today, and I was on a panel yesterday, and I talked about, I used the term shrinking coverage. And what I mean by shrinking coverage is not that there isn't an insurance company out there from whom you can buy professional liability insurance. It's not a situation like we saw back in the 80s when companies were getting out of malpractice coverage. Instead, it's a situation where there's plenty of companies to buy insurance from. What is happening is that the insurance companies are they're smart folks, and they're being very careful about the risks that they're writing, and the way they have protected themselves, if you will, through a number of vehicles. One of them is what we call defense within limits coverage, or Pac-Man coverage, or diminishing limits coverage. And what that basically is that you may have a policy for $300,000 or $1 million, but it may provide that the defense of any claim that's filed against you will reduce the limits of that coverage. That is allowed under the insurance regulations of this state. There is a restriction to defense within limits in professional liability policies, but the exceptions are, I don't want to call it, well, I will. I'll just call a spade a shovel. They're almost illusory. It takes almost nothing for an insurance company to comply with the exceptions so that you can end up, in some instances, with a policy of $300,000 or $1 million, which is totally diminishing, or can be totally diminished. And so there's that. There is what we're also seeing today in the insurance world, and this is a little bit of a product of the Lawyers Professional Liability Insurance Committee. Some years ago, working with the Supreme Court, we came up with the rule that all of you, I hope, are familiar with, and that is that you don't have to have professional liability insurance, but if you don't, you have to give a specific written notice. It's in the rule to your client, so that they sign it saying, I know you don't have professional liability insurance. Lots of folks are getting coverage now. Lots of companies are coming in and non-renewing. And then what happens is the lawyer saying, well, I got to have insurance coverage because I don't want my clients to sign this form and whatnot. So they'll go out and get coverage, and they don't pay attention to the fact that they don't pay attention to the prior act's date. And so they'll go out and they'll get a company to write their insurance, and they'll say, gosh, that's great. I now have complied with the rule, and they'll march on, not knowing that the insurance coverage they have only provides coverage for them from that date going forward. You have no tail, as they say. The other area, the other pitfall that we talked about yesterday is failure to give notice of potential or threatened claims. Very quickly, professional liability insurance is claims-made insurance. It goes from January 1 to January 1, and then it's over. Your policy will provide what it calls a duty or obligation to notify the carrier of any potential or threatened claim. Someone doesn't have to come down and file a lawsuit against you, but if you feel you've made a mistake and there's a potential claim there, you define potential however you like it. If you don't give notice of that potential or threatened claim during that claim period, and then you renew with that carrier or you get new coverage, and you don't give them notice on your application of that potential claim, and then a year later or 2 years later you're sued, there'll be no coverage, and you are bare. By writing that letter that lawyers seem to find so difficult to do because they think they're admitting a mistake, or they don't want the carrier to know that they've maybe made a mistake because maybe it'll affect their rates. It's a little bit like in car insurance, people used to not turn in their windshield when they had a cracked windshield because they thought the carrier would cancel them. Same thinking. All you have to do is write a letter to the company saying, you know, I don't think I made a mistake, but maybe I did, or the client has looked at me sideways, or the client has raised some question, or the client is disgruntled, and I don't think it's going to turn into a claim, but I have an obligation under paragraph 8 of my policy to notify you of any potential or threatened claims. If 2 years, 3 years, 4 years later, a client back in that coverage period, if they file a suit against you, you have coverage under that policy. You would not have coverage under your current policy. So that's what I mean by shrinking coverage. You need to do two things. Get a broker, work with a broker, read your policies. I would suggest to you that as I say, we have the Lawyers Professional Liability Insurance Committee. We're in the bar directory. Any one of those folks. John, as I've already pointed out, has been on the committee forever. As a past chair, there's Jack Brandt, there's Jerry Dixon, there's myself, there's Josh Allison, there's Damon Eli. There's a whole host of folks who will be happy to get a phone call from you saying, could you take a moment and just answer some questions for me about your policy? Pay attention to your insurance coverage.
Briggs, thank you. Justice Chavez, or let's see, Bill, do you want to comment on
Something.
Yeah,
I'll
I got
comment on
those out.
something. No, I've got it. It picks up a little bit on the reporting to your insurance carrier. How many of you have heard of the concept of loss frame or loss frame analysis? Any of you? It's a concept out of psychology. It's a concept out of psychology that started in gambling, but it's probably most obvious in the lawyer context in the Watergate era. Anybody remember Watergate? Yeah, if you remember Watergate, President Nixon and the scandal associated with it that eventually ended his presidency, and a lot of lawyers who were involved, some of whom went to jail, including his general counsel, Mr. Dean, who I had the opportunity to hear from, who taught me some about loss frame analysis. And loss frame analysis is the concept that when you are in a difficult position with unpleasant outcomes, rather than objectively evaluate them and decide that you're going to have to take one of those unpleasant outcomes and make a good choice about which is going to be the least unpleasant, you start developing scenarios in which you will convince yourself there's another way out. And when you convince yourself there's another way out because you're not evaluating it objectively, you start making an increasing series of bad decisions that make it much worse for you. And if you look back at the Watergate era, that's what happened with those folks. Probably that presidency could have survived if they had taken some of the hard choice. But more importantly, and where I'm getting with this, is if they had gotten third-party objective analysis. Well, when you get a malpractice claim against you, or a client threatening it, or a disciplinary complaint, your initial reaction is probably going to be one of three things. Either you will take it head on and you will get somebody to help you with it, which is the smart thing, or you will start engaging in some loss frame analysis, and what you will do is either become extremely belligerent and angry How dare they? I did a great job for this person. Why are they complaining to the disciplinary counsel? This is ridiculous. I'm going to write a scathing letter to my client. I'm going to sue them for the fees they owe me, and I'm going to tell disciplinary counsel that they are the dumbest people on the face of the earth, right? That's one reaction you can have, and that's fine. People tell me I'm dumb almost every day. That's going to roll off my back. But that increases your personal investment in the case such that you're not objectively evaluating what's going on. The other reaction that we sometimes see attorneys have is what Justice Chavez has called the going fetal, in which case they sort of just ball up and don't do anything. They don't respond at all. And what that can result in, under our rules now, 17207, is a petition to the court for an administrative suspension of a license until the lawyer does cooperate. So it's not a good outcome either. Most malpractice carriers, and this is not a pitch for full employment of John Bannerman and Jerry Dixon and some of the other folks, Briggs in the audience, but most malpractice carriers now will provide, either as part of the premium you're already paying or for a little bit of a bump, disciplinary counsel coverage, meaning that you can get a lawyer to come and help you. And it's the smart thing to do, because now you have a third-party objective who's going to come in and help you analyze it. And most of those lawyers who do that work are experienced in the disciplinary system. They know how to work you through it. The disciplinary system is a little bit different than traditional litigation, and if you came to the mock trial session we did yesterday, I explained it there. We are not about trying to win or punish lawyers or beat you. It's not your typical advocacy setting. The goal is to find the truth of what happened. If there has been misconduct, to respond accordingly. But that's a different model than us trying to win or you trying to win. If you're representing yourself, there's a tendency to try and win, and that may not be actually in your best interest. When you get the first letter from us, am I telling you you have to get a lawyer then? I'm not telling you you have to get a lawyer at all. You get that first letter, you may know that there's no validity to the claim. You're able to evaluate it objectively and respond to us accordingly. That might be fine. If we're starting to invite you to come down to our office for a personal visit, if we're asking you to be deposed, if we send you something that's labeled specification of charges, now you're in a lot deeper water, and you're probably going to, at that point, not be nearly as objective as you should be. That's the time to make sure you start talking to an attorney.
Good, thank you.
That's
Good advice.
That's great advice. Actually, Briggs has great advice too. Lawyers shouldn't be like plumbers and auto repair people, right? The plumber has leaky faucets, the auto mechanic's car doesn't run just right, and lawyers are the worst at looking at their own contracts. And so I'm glad to hear that there's a resource available to you as lawyers to make sure that you understand the content of your policy. It's also important to know that if you don't carry insurance, that we do have that mandatory disclosure rule. But as important is the fact that you may have had insurance at the time that you signed up the client, but if during that representation you no longer have insurance, same disclosure requirement. You have to notify your client in writing and get them to countersign that they understand that you do not have the coverage. So they're very important to follow those rules. Those are the mistakes that will get you before Bill Sleece. The other thing is objectivity that I wanted to talk about. Bill made the point about the lawyer who has access to a lawyer in the event that a complaint is lodged against them. It's very important for you to, I think, get a lawyer as early as possible. It's going to be paid for. You've paid the premium, you might as well do it. The worst cases we have seen in our court, and there are actually cases that have ended up in disbarment, and in New Mexico, disbarment is permanent now. So if you get disbarred by this court, you lose your license forever. You don't get to reapply in 5 years. And the other states engage in reciprocal discipline. And the lawyers that I have seen that have come before us, that have represented themselves, have made the mistake of being too emotionally invested in their case, too defensive. The best thing a lawyer does for a client, from my perspective, is they can objectively review the merits of the case and offer the client objective advice. If you adopt the emotions of your client, you are doing your client a disservice. So the lawyer who actually defends himself in a disciplinary proceeding and is too emotional to be objective about it, what we've discovered is that they tell a lie. And then they tell a lie to cover up that lie. And they forget that when they show up in court and they have 5 justices asking them questions and they're representing themselves, they get to be interrogated by the justices. And we're actually not that dumb. We can ask a few questions, and before you know it, that lawyer is out there on the very end of the branch until they fall off. Because our role as justices on the Supreme Court is to protect the public. That's the concept of discipline. And the lawyer who loses the objectivity just doesn't have it in him or her, and they haven't, to properly defend themselves. In fact, they come in so defensive when the facts against them are so clear that it's alarming. So, objectivity, that's the sole reason why we are good lawyers on behalf of clients, because we're able to maintain that objectivity. Hopefully, you're able to not adopt the emotions of your client so that you can aggressively but accurately advise your clients and represent them in court. I was supposed to talk about something else, but let me summarize. The idea was basically somewhat to do with civility, and I think I'll summarize it by what Mark Twain said. Mark Twain said something to the effect of, it's not a good idea to argue with a fool in public, because the onlooker may not know who is who.
Thank you, Justice Chavez. You know, Justice Chavez talked about showing respect for the court, and I'd like to talk just a moment about showing respect for opposing counsel. We've all been in a situation where the other attorney just annoys the heck out of us, and there's a great temptation to respond in kind. I encourage you not to do so. We're all colleagues. Opposing counsel tries to do their best to represent their client in whatever case or matter you have. And even if you disagree with their point of view, I urge you to resist the decision to send off a scathing letter to them or an email when you're angry. If you do really need to talk to them about something, I encourage you, after the emotions have calmed down, to set a time to either meet with them or talk to them one-on-one and try to overcome those kinds of feelings, because they only escalate over time. If you really feel you've got to write a scathing letter or a hostile email to tell the other attorney that they're a thieving, lying, and deceitful person, I encourage you to go ahead and write it, but then either shred it or put it in your wastebasket. Take care.
You'll
Briggs?
feel better, right?
That's right.
Could you talk to us some about notice of potential threat? Oh, you've done that. Okay, you had something else you wanted to do. You jumped ahead on that one.
Let me, I mentioned to you all the fact that there's a double-edged sword to emails, email communication. Don had been sending out outlines for us, and I prepared off one of the outlines, which has down at the bottom, DLJ discussion draft 7616. And there was I guess a final draft. So I didn't get the final draft. I got it, I didn't see it. Be careful of your email. I do want to talk, however. I've mentioned to you about notice and threaten potential claims. I want to talk to you about something today that is kind of in the forefront of our practice right now in the area of I hesitate to call them mistakes, but I guess maybe it is a mistake. It's certainly the object of a number of legal malpractice cases now, and that's negligent settlement. That's the new rage. And that kind of ties in a little bit with what others have said this morning about being honest and accurate in your communications with clients. When you get a case and you evaluate it, there is that tendency to say to a client, gosh, you've got a great case, you can't lose. There's also that situation where the lawyer will write a letter and provide an evaluation which truly isn't realistic. This case is $1 million case, or we can get this or whatever. And you do that at the beginning, you do that at a point in time when you haven't evaluated the case, you haven't really looked at the law, you don't have all the facts, yet you're setting the expectations of this client. Now let me stop for a minute, ask you all to pause. Pretend that a legal malpractice case has been filed against you for missing a statute of limitations. And you go to your defense lawyer, you give him the file, and the defense lawyer gets to the bottom of your correspondence chipboard, and he finds this letter, third day out in the representation, where you've told the client they've got $1 million case. And immediately the lawyer said, the sued lawyer said, this case isn't worth a damn. This isn't, you know, this is, you know, it's those kind of mistakes that lawyers make because we want to tell, we feel we have an obligation to tell clients good news. One of our hardest obligations is that we don't deliver good news all the time. It'd be nice if we could. The hardest part of being a lawyer is to deliver bad news, to be honest and realistic with a client throughout the representations. I sometimes am a little too negative. I understand that. It's a character flaw of mine. It's probably because I don't feel good enough about myself as a lawyer, but I tend to tell people this is a tough case, and then if I can pull it out and I think, well, gosh, look how good I am. But let me get to negligent settlement. And I don't have an answer for this, but what we're seeing is a lot of lawsuits where a client will enter into a settlement. Often it's after a mediation. There's a mediation statement or settlement agreement or understanding signed, a release is signed, and then they say, no, I didn't want to do this. And had the lawyer told me this, had the lawyer told me that, had I known such and such, I would never have entered into that settlement. We're defending several of them right now, and they are incredibly difficult cases to defend. And I don't know how to, I don't have the answer for all of you, but what I'm saying to you is you need to knock yourself out. Before you settle a case, you want, it's so easy. We've all been in mediations, and you've been there all day and back and forth and all the stuff that goes on in mediations, and mediators are beating on clients, and they enter into a settlement, and then they go home and they have the second thoughts about it. I will tell you a story, and I'll use a name because I think he deserves credit. It's Doug Foster, who has whipped me every way but loose a couple times. He's just a fine lawyer. Not long ago, I was in a case where we were on the same side, having kind of co-defendants, and we had a long mediation one night. And it went into the early evening, and the client was a woman. It was some kind of hard, tragic facts, and you could see, he could see that his client, who was about ready to enter into a settlement, was being pressured by the mediator, was being pressured by the other side, saying, take it or leave it. If you don't do it, this offer will not be there tomorrow morning. And Doug, I think, now is retired or was close to retiring. It was a huge case. I think he very much wanted to have it settled that day as much as everybody else. And as I say, every once in a while, Doug has whipped me a lot, and but because he's a good lawyer. Doug stopped that night, and he said to this client, he said, you know, I don't think you're comfortable with this, and I'm not going to let you settle or enter into this settlement tonight. I don't care what the other side says. I want you to spend the night, and I want you to think about it, and then tomorrow, and when you've had a good rest and we can look at it, then we'll see if you really want to settle this case. It's those kind of things you've got to do. You have to fully evaluate the case for your client. You need to lay it out in writing, the risks and the pluses and the minuses. That's all I know to tell you in terms of avoiding the client who says, I wish we hadn't settled. But what happens is you get down, you try a summary judgment on one of those cases. You ain't going to get it because there's a question of fact there. So I wish I had an answer for you, but that's a mistake all of us can make, and so be careful.
Thanks, Briggs. Bill, did you have some additional comments?
Just quickly, it'll take maybe a minute. Much as it pains me personally, I'm a member of the Senior Lawyers Division, involuntarily so. as actually are everyone on this panel, and without, I'll keep my eyes averted, so are many of you. About 2.5, 3 years ago, in a conversation with Justice Chavez and Briggs Cheney, the court formed a succession and transition committee. If you are not doing succession planning for your practice, then you are making one of the biggest mistakes you can make as a lawyer. Particularly if you are in a sole practice, and it's not that I'm picking on you, you sole practitioners, it's that your clients have you and only you when they've come into that door, and if there is no plan in place, if something unexpected happens to you that takes you out of practice for an extended period of time, then your clients go adrift, and currently the default model is an inventory attorney is appointed through the court, usually it's our office, and we are going to disassemble your practice. So you'll come back in 6 months to an empty practice. That's tragic. It's tragic for you, it's tragic for your clients. The State Bar Succession, the Supreme Court Succession and Transition Committee has developed great materials. They're available on the State Bar website. Go visit them. You can get anything from the Land Rover of succession planning documents to the Chevy Bel Air of succession planning documents. It protects you, protects your family, protects your clients. I encourage you, please do it, because the last thing I want to do is destroy your practice when you become sick.
Thank you very much, and I can't overemphasize the importance of what he just said, particularly for those of us who have met the minimum qualifications for being in the Senior Lawyer Committee. Judge Chavez, closing comments?
Actually, instead of closing comments, are there any mediators in the audience? 1, 2 mediators, that's it. Wow, interesting. I'm just going to ask you a question because I was interested in what Briggs was talking about. Have you had the experience of lawyers showing up at your mediations expecting you to evaluate the cases? Okay, that's a big mistake. The mediator is not the lawyer. You as a lawyer, you're going to face malpractice litigation if you have not adequately advised and prepared your client for the mediation, including an appropriate evaluation of the merits of the case. It's when they leave shocked that they are being pressured and having to sign on the dotted line at a mediation without having the benefit of meeting in private with their attorney to explain the strengths and weaknesses of their case that creates problems. Those are my closing comments.
Very good. It's now 10:45. Just a brief comment. I want to thank not only our panel members for the excellent comments and discussion that we've had, but thank you for your attendance at this seminar. I hope it benefits you in your practice, and I wish you very well in the remainder of your practice. Thank you very much for coming.